Dennis Marburger of the Michigan Campaign for Liberty, and Shane Trejo of the Michigan 10th Amendment Center. Whoever would like to start first is fine.
Thank you, Mr. Chairman and distinguished members of the committee. We appreciate your time here. This is actually a very interesting time to be discussing this. Yesterday was the anniversary of the birth of James Otis Jr., who in 1761 actually confronted this very question in Massachusetts regarding the general writs of assistance, which British agents were writing themselves to go into the homes and search the effects of British Americans at that time, 15 years before the Declaration of Independence was written. He took up this very issue, and this is one of the items that actually was quite a motivator for the American Revolutionary patriots of that generation. I would like to, I will have a few additional remarks about that, but I also would like to read the written testimony of Mike Meharry, who is the National Communications Director of the 10th Amendment Center. I think he did a very fine job in putting this in proper perspective. Mike writes, in 1975, Senator Frank Church warned us about the U.S. surveillance state, saying that it had the potential for total tyranny. Let that sink in for just a moment. That was 40 years ago, before everybody used email, before cell phones, before widespread use of the internet. If the potential for total tyranny existed in 1975, where are we today? And yet Congress has not taken any action in more than 40 years. In fact, Congress actually has made things worse. Just last month, Congress reauthorized Section 702 of the FISA Amendment Act. As Judge Andrew Napolitano explained, quote, the FISA-created process permits a secret court in Washington to issue general warrants based on the government's need to gather intelligence about national security from foreigners among us. It pretends that the standard is probable cause of foreign agency, but this has now morphed into the issuance of general warrants whenever the government wants them, unquote. A typical FISA warrant authorizes government surveillance on all landlines, mobile devices, and desktop computers in a given area. While the process was created to monitor foreign agents, it sweeps up reams of data belonging to Americans. There is a great deal of speculation that this was the mechanism used to surveil candidate Trump. Before approving a 6-year extension of Section 702, the House voted to kill an amendment that would have overhauled the surveillance program and addressed some privacy concerns. Provisions in the amendment would have required agents to get warrants in most cases before hunting for and reading Americans' emails and other messages that had been swept up under the program. This is yet another indication that we can't count on Congress to limit U.S. surveillance programs. That's why it's imperative that you take this concrete step to support the Fourth Amendment. The effect of HB 4430 is very straightforward. It simply prohibits state support when a federal agency engages in illegal, warrantless electronic surveillance. Now, there are a couple of questions you may be asking yourselves. First, does the state really have the authority to withhold material support from the federal government? The answer to this question is actually an emphatic yes. HB 4430 rests on a well-established legal principle known as the anti-commandeering doctrine. Simply put, the federal government cannot force states to help implement federal programs or enforce federal acts. The anti-commandeering doctrine is based primarily on 4 Supreme Court cases dating all the way back to 1842. Prince versus U.S. serves as the cornerstone. Quote, we held in New York that Congress cannot compel the states to enact or enforce a federal regulatory program. Today we hold that Congress cannot circumvent that prohibition by conscripting the states' officers directly. The federal government may neither issue directives requiring the states to address particular problems, nor command the states' officers or those of their political subdivisions to administer or enforce a federal regulatory program. It matters not whether policy making is involved, and no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. So, and then unquote. So legally, the state of Michigan has every right and authority to determine how it will utilize its personnel and resources. It can withhold material support from the federal government, even if the federal government is pursuing a perfectly constitutional policy. And of course, warrantless surveillance is anything but constitutional. The second question is more philosophical than legal. Why should we even take a stand on this? Why is it our business to question the federal government? Because this is a fundamental role of the state. In 1807, Connecticut Governor John Trumbull said, whenever our national legislature is led to overleap the prescribed bounds of their constitutional powers on the state legislatures, in great emergencies, devolves the arduous task. It is their right. It becomes their duty to interpose their protecting shield between the right and liberty of the people and the assumed power of the general government, unquote. The U.S. Constitution is the fundamental law of the land. You each swore an oath to support the Constitution of the United States and the Constitution of Michigan. We know from documents released by Edward Snowden and from the testimony of other whistleblowers like Bill Binney, that federal agencies do engage in warrantless surveillance. This is not some kind of theoretical abstraction. It happens. And when it does, the state of Michigan should not be complicit. A yes vote for 4430 is a vote for the Fourth Amendment. It's a vote for the Constitution. It's a vote for the rule of law. I urge you to cast that vote. See, that's Mr. Meharry's, I think, very eloquent and important written testimony. And I would like to point out, as he mentions there, the governor of Connecticut mentioned about the duty. James Madison, our third president, said that when the federal government oversteps its bounds, the states are duty-bound to interpose. He also said in Federalist 46, when the anti-ratification forces said, that government's going to be way too tyrannical. They're getting way too much power. And John Adams, he wasn't the president yet, of course, but he did say, when that happens, the means of opposition are numerous and close at hand. And one of the things he mentioned was non-cooperation with officers of the Union. That was James Madison who said that. And then in 1798, when President Adams, the second constitutional president, was trying to usurp power, Adams and Jefferson both said that the rightful remedy is a nullification of that act, because if it's not something that is delegated or granted in the Constitution to the general government, which we now call the federal government, it's not law, it's null and void and of no effect. In effect, going back to our friend James Otis Jr., he said, a man's home is his castle. Whilst he is inside it and he is quiet and bothering no one may enter, no one may bother him. He said, with the general writs of assistance, just as with this warrantless surveillance today, that is indeed what is happening. People are bothered. We are not safe in our papers, in our effects, in our homes. We know from now the Snowden revelations that the NSA has put backdoors into computers, into the cell phones, that people live on these things. This is totally adverse to what the founders wanted, what any free people would want. It's even worth noting that the state of Michigan did practice this very non-cooperation and anti-commandeering effect in fighting the Fugitive Slave Acts. In the 1850s, Michigan passed personal liberty laws and said none of the state of Michigan's resources will be used to enforce that odious situation. You cannot use our courts, our jails, nothing. We will not cooperate. That was a noble thing to do there. It's a noble thing to do now. There was a gentleman named Joshua Glover who was a runaway slave who became a famous case back then. And Joshua, a heroic man, he had a small log cabin. It was very modest. But when he closed that door, no one could lawfully enter. Just as James Otis Jr. said, whether you're king or commodore, no one may enter. No one could enter Joshua Glover's very modest dwelling. Somebody did, they tricked him, and then he was later taken away, but he was eventually free, so that's the good news. But today, we no longer have the protection that we should have against people entering our dwellings and entering our most sacred things because of what the federal government is doing unconstitutionally, and that's why I strongly urge you to support and to pass through the committee onto the general floor of Representative Howrell's excellent legislation. Thank you very much.
And my name is Shane Trejo, and I am the State Director of the Michigan 10th Amendment Center, a chapter of a national organization that works to safeguard the Bill of Rights through state-level action. And I came here to speak in favor of HB 4430 today and implore the committee to approve this crucial legislation. HB 4430 would deny material support and compliance at the state level toward federal surveillance that is abhorrent to the Fourth Amendment. Unwarranted surveillance is one of the most pressing issues of our time, as Dennis explained very well, mostly through leaks that have come out, such as those produced by Edward Snowden regarding NSA spying capabilities, or the WikiLeaks Vault 7 revelations that exposed the capability of the CIA's hacking operations. We're finally starting to realize the true nature of the surveillance state and how it actually operates. Clouded in secrecy, the most powerful bureaucracy in the history of the world has been created without most of us knowing anything about it. And it constantly operates in violation of our privacy rights without any real oversight or basic regard for constitutional fidelity. As we saw with the recent FISA memo regarding the FBI and what they were doing in terms of spying, These powers can and will be used to manipulate our political process. When these powers fall into the wrong hands, they can completely jeopardize the integrity of our democracy. The treasure trove of information being collected in these federal databases can be used by individuals or special interests to manipulate our political system. And if foreign hackers can get their hands on the data, it can even jeopardize national security as well. Unfortunately, these policies have not changed. The surveillance state has only grown in power over the past several decades, and there is no impetus for the National Congress to rein it in or enact basic reform. So passing HB 4430 would send a message that could resonate to other states and resonate upward that we need to institute substantive reforms to the surveillance state. Based on hundreds of years of case law approved by the Supreme Court known as the anti-commandeering doctrine, HB 4430 rests on firm constitutional grounds, as any state can choose whether or not to comply with a federal regulatory program for whatever circumstances that state so chooses. While the legislation would only pertain to the state of Michigan's support of the surveillance state, it'd be a great first step in showing that we are serious about protecting the Fourth Amendment and the privacy of our citizens. If enough states enact these measures, the surveillance state would actually have to use its resources to protect the safety and security of all Americans rather than continuously spying and gathering information on what is primarily law-abiding American citizens. Michigan should become a national leader on this particular issue and pass HB 4430. Thank you for your time.
Any questions? Seeing none, thank you.
Thank you.
Okay, Paul Teros of Birmingham.
Some of you will be running for re-election. Some will be running for higher office. I am here to tell you the grassroots activists are watching you. We will remember what you do or what you don't do regarding this bill. If you are truly defenders of our constitutional rights, you must pass this bill out of committee so it can move forward. The Fourth Amendment of the United States Constitution prohibits unreasonable searches and seizures. It requires governmental searches and seizures be conducted only upon issuance of a warrant based upon probable cause. This bill would still allow the state and its political subdivisions to assist federal agencies in collecting electronic data pursuant to a warrant. But it would prohibit the state of Michigan and its political subdivisions in cooperating with a federal agency if the agency does not have a warrant based upon probable cause. Presently, state and local law enforcement agencies regularly provide surveillance data to the federal government. They collect and store information from cell site simulators, otherwise known as stingrays. Stingrays are military-grade equipment and have no business being used on law-abiding American citizens. They use automated license plate readers, drones, facial recognition systems, and even smart meters. You can help Michigan be a leader in stopping this information sharing environment. I hear so much about basic human rights. Not to be spied on by your government is a basic human right. Do you fear the American people so much that you feel you have to spy on us without probable cause? If I spied on you, collected and stored your phone calls, kept track of your movements, I would be arrested. Why then is it acceptable for state and local police to do this without a warrant? You need to pass this bill out of committee so we can once again truthfully say, land of the free. Thank you.
Okay, thank you.